Brian Bradley, thanks so much for coming on the Infinite Banking Radio, man. How's it going today?
Good, man. Thanks so much for having me on. And it's going to be an important topic, a fun topic. I'm not anyone's legal guru or attorney here, so we're going to be talking generalities. But I definitely think I'm going to be like blowing up some status quo stuff and misconceptions and breaking some interesting concepts down. I think that will help your listeners and you understand this crazy world.
Well, that's half of the battle, and that's more than half the reason why you're on this is because the majority of our listeners don't like to listen to what the talking heads on CNBC and the financial entertainers tell them what to think or what to do. So thanks for coming on, man. So Brian, tell us just kind of your story, man, how you got into what you're doing, and more importantly, your story as to how you protect clients in regards to their asset protection.
For sure. So like I got into asset protection from the litigation and trial side of law and having clients, being sued and their lives just turned completely upside down coming to me after they were already being sued. And at that point, you're just too far down the rabbit hole. It's like trying to go and get car insurance after you already got in a car accident or after your house caught on fire. It's nothing you can do for you. So you have to be proactive. You have to set all the stuff up beforehand. And then, people calling in, I just see a lot of people thinking, that they don't need to do anything until after the fact or just ride lady luck. Well, that's just wishful thinking. That doesn't work for you. Or they think they can just ride their insurance, but they forget insurance companies are businesses. Even if you have an umbrella policy, they're there for the little stuff, but then they have insurance defense teams and attorneys. Their job is to find out what claims we don't want to pay, and large claims create legal wiggle room to get out and not pay them. And you see this a lot with clients like, oh, I had the, $1 million insurance policy plus an umbrella policy. And now my insurance company, my umbrella walked away. Like, didn't see that coming, and just realize insurance is good. It's a good thing to have. But at the end of the day, they are a business and they are a for-profit business, which means like they're going to take your premiums and try to not pay, claim amounts. And then when we get into, the world of asset protection, we really need to think about our legal system. I know you and I are talking about this a little bit, before we hit record, and like why we even are protecting ourselves. And it's just the legal system is completely broken. We're just a sue happy nirvana now. And if you don't mind me setting the stage a little bit further, we can add some context into what we're actually fighting against.
Absolutely, man. Bring it on. I mean, that's what we're here for, man. I want to hear the truth, if that makes sense.
Yeah. So the legal system, has drastically changed over the last 40 years. It's no longer about justice, but really redistributing your wealth from the haves, which is you, your listeners are trying to have things, to the have-nots. But over the past 40 years, things that didn't happen in the past or that weren't allowed to happen in the past, like contingency fee lawyers or law firm advertising, they're commonplace now. Career politicians who happen to be lawyers in the beginning. And this created a cultural shift of a predatory legal system that's no longer about justice, but it's about profits. And then when you get into the world of high net worth and affluent families and kind of like, the level of protection that I deal with, you guys are taking in a macroeconomic global look about what's going on. And the big picture really is that we have a global financial system that has, structurally deep-rooted issues, along with government-backed fiat currencies that are now in question. And then also, this includes the US and the US dollar, monetary policies that are really simple to explain, inflate or die. And then we got governments looking for, deep and accessible pools of financing, meaning your money and your assets, along with financial repression, monetary, economic manipulation. And all this is just adding more challenges to protect your wealth. And then, we woke up, a couple of days ago with, this US banking system, issues, right? That, people are asking questions on. And I think it just adds into the problem and the frustration and fear of people, because we have a US banking system that's built on what's called fractional reserve banking. And, it's also built around not letting banks fail. What this means is that US banks only need to keep a fraction of the money in reserves and then lend the rest of the money out. So they make money by lending out your money and on the fees that they charge you. So, when you got the tier one capital ratio, meaning the amount the bank has to have, it's only 10%. So they only have to have 10% of the money on the deposits. So this actually makes it very easy for a bank to get a run on it and fail. And that is why the US created the FDIC, because before that, banks would actually fail all the time. It was common. And so we wanted to create, security around banks. And, it's fine if a bank fails, but only a few. The system can handle that, but not a bulk of them, or all of them. And that's why in 2008, the government was so quick to step in, because we couldn't handle a full meltdown of the system. And we were really, really close to having a complete meltdown and failure of all the banking system. And now how this relates to asset protection is that there are other banking systems in the world that are built on other systems, right? Like Switzerland, it's built on a trust system where they charge you an interest on holding your money. So they're making money only on the fees. They're not out lending your money, meaning, they're not risking your money like, the Silicon Valley Bank did and invested all their money in, risky startups. So when you open, for example, like a Swiss bank account, you never open it up in your own name. You open it up in your trust, like, a hybrid trust, which we'll talk about. But Swiss banks are private. They're private banks, not like our banks in the US. So that's why your money is more secure in, for example, like offshore Swiss banks than, and why they're actually charging you more exuberant fees. So at the end of the day, what asset protection really is doing is it's your modern best bet to level this crazy playing field by using all the different legal tools that we have. And then this is in return trying to give you peace of mind, lifestyle preservation, and really combating how collectible you are from lawsuits.
Man, absolutely. I like you to, because I never really knew that about the Swiss banks in regards to their trusts and things like that. Can you go into the differences between how you make deposits in a United States bank versus how you might make a deposit in a Swiss bank? And you always hear people talking about offshore accounts and things like that. I don't want to dive too into the weeds, but you obviously are pretty sophisticated when it comes to this. Do you mind kind of diving into what the difference between those two are?
Yeah, there's not really much of a difference. Like you're just managing your bank account like you would, like you have your online apps and wire transfers. It's just when you're using offshore accounts, you generally have to report all offshore wire fundings going on to the government. So you just have to make sure that whenever you're doing offshore banking, you're always going to end up having to do like FATCA disclosures, IS disclosures, which you wouldn't be doing, with your domestic bank account, for example. Otherwise, you get into like offshore wire fraud issues if you don't disclose what money you're moving offshore. But it's a very streamlined system. It's actually more user friendly, if you can even think of an easier way, than our domestic banking system. It's just very, very secure. And so I would say I wouldn't be really concerned about creating offshore accounts or using offshore accounts because they've been in existence longer than the US has been in existence. So like, it's just, we're so isolated in our own little island bubble that we have here, because we don't have other countries really beyond Canada and Mexico touching us. We never had to deal with like, money moving from country to country, and not as many people were as responsible for their own finances and investing as people are today.
So can you go into some details again? Let's dive into a little bit of the asset protection side. So whether it's real estate, whether it's a startup company, whatever the banking systems are, what do you what's your expertise and what do you focus on with your clients on how to maintain and preserve their capital and their separation from litigation?
Yeah, absolutely, man. So like, first, I think we look at it as like, what is this weird word asset protection, right? And then like the tools that we're going to use. So asset protection is not traditional estate planning. It's modern estate planning. And what we're doing is placing legal barriers between your assets and the creditor, the person trying to sue you, beforehand, before it's needed. It's kind of the key word. It's like a barrier, like a safe for your gold or your guns or valuables. Anything of value you want to put behind the legal barrier and out of your personal name so that it can't be attached easily with a lien or reached. Think of like the Tony Robbins saying, I love it, success leaves clues, right? The rich don't own things in their personal names. Their businesses do, their trusts do. They just get the beneficial use and enjoyment out of them while separating out the liability side. Now, what asset protection is not, it's not hiding money. It's not moving assets out of the country or into business entities to avoid paying, taxes on it. That's illegal. You're taxed on your worldwide income. So just remember that if you're a US resident. You can't just, you hear some promoters and people and shysters saying, move your money into this offshore account or these offshore business entity or this offshore trust and don't pay any taxes on it ever until you bring it back. So never bring it back to the US. Sorry, that's, tax fraud, tax ignorance. You're going to get audited. And if you don't have the money and the fees and penalty fees for that, you're going to go to jail. Whether you got duped into it or not. So just remember asset protection. If you call me, and I get this call a lot recently because of this, the craziness going on in the economy. Hey, I want to protect my assets and, I don't want to pay any taxes. What can you do for me? I'm like, that's not asset protection. There are steps to mitigate and decrease how much you pay in taxes. That's called talking with your CPA and wealth managers to utilize the treasure map of the IRS tax code on what to invest in strategies. Tax mitigation is perfectly legal. Hiding assets and not reporting them is fraudulent. So just remember the distinction between those two.
100%. Oh, yeah. Go ahead. Sorry.
No, I was going to say, like, how we go about it, though, is layering systems using like LLCs, management companies, and asset protection trust. And so to break these concepts down, because there's so many different ways that you can go about it, is I want you to think about winter. Okay. When it comes to asset protection, we have different layers. The first layer is your base layer. Okay. It sits on your skin. These are LLCs and insurance. And this is when you're just starting out investing and you have like 0 to 3 units or properties. Your net worth is generally going to be below $250,000. And you're a new investor, new doctor. You don't have much, in your bank, but you're starting to get something going. So you need to just like start a base foundation layer, LLCs and insurance. And then as you grow and you add more assets and you hit around that like kind of like 4-unit mark, or you're investing in multiple states like Tennessee and Florida. So you're getting more LLCs that you need to use. Your net worth is increasing. Now you're around like $500,000, $700,000 net. You want a mid layer, which is usually going to be a little bit thicker. It's like a merino wool sweater or a cardigan for you ladies. This is a management company, or like some people you hear use Wyoming LLCs. We use limited partnerships. But the idea is you're having your base layer LLCs disregarded, flowing up into a management company or a limited partnership. So you maintain one tax filing, you can start protecting more assets, and you have a second degree of layer, second layer of protection. And then you hit that third, layer, that outer shell waterproof layer. You're around 1 million net. You have more risk and liability in your job. Now you're a resident, or surgeon. You're making some money, investing in your stock portfolio. Got probably 6 rental properties or more. So you have a lot more exposure. Your big red button is really visible now. You're a mark. You're a target. So this outer shell waterproof layer, this keeps you nice and dry and warm, when the weather is really bad. This is your doomsday lawsuit protection. This is your asset protection trust, or what we use as a hybrid trust. But by layering, you're now more flexible and you can adjust and make yourself more comfortable. And this is how, what an asset protection plan, depending on where you're at, doesn't matter what layer we're at. We can start at the base layer or, wherever you're at, depends on your profile, but that's how you layer up a system.
So as a physician, or as a high income earning engineer, or an individual real estate professional, somebody else, when at least when I was first starting, is kind of similar to what you just mentioned. I was thinking the only asset protection that I needed was an LLC, just to get it out of my personal name. And then I realized really quickly, talking with accountants and attorneys and people like you're like, this is really not all that protective as what it's meant to be. Like you said, you got these layers. Can you go into some details? Like, let's just use an example really quick. Let's say there's a guy that's out there. He's 35 years old. He's got 6 rental properties. He is an engineer that makes $200,000 a year, and he's got 3 kids. If he didn't have any LLC, he had all his rentals in his own name, and he had a wife and these children, what would you, as you just meeting him for the first time, what is that kind of example? What would the steps that you would take to go to help him protect his assets?
Yeah, so one, they would just be like, okay, let's identify a risk profile. Like, what are the assets you own? What states are they owned in? What's the title in? Is title in your personal name, or is title in an LLC? And then how risky are you? Because I'm trying to figure out how much exposed equity you have, to where if you get sued, where can someone get access to it from? So I take 401ks out of the equation because they're protected by ERISA. I take your IRAs out of the equation because a lot of states have great exemptions for IRAs. So I'm really looking at the equity in your personal home, the equity in your rental properties, personal brokerage stock accounts, cryptocurrencies, cash, rental properties, equity and rental properties. And then I'm looking at what's your day job. If you're just a W-2 employee at some, random tech company, you don't have much risk in your personal life. So your main risk will be negligence of you driving around your car and plowing somebody over with your car, or if you have rental properties, and, something happening with the rental properties. So we're just trying to create a risk profile with how much equity that you have. Once we know that, then we can say, okay, hey, with the hybrid, hypothetical, you did like 6 properties. Let's say like the equity is around like 600,000, maybe they would need a couple LLCs depending on the states that they're investing in. We would create the LLCs, and you want to create them in the state that the asset's in, because you can't go buy another state's more beneficial laws and bring them to the state you're getting sued at. It's a big misconception. It's called just jurisdiction. When you're filing a lawsuit has to be filed in the proper jurisdiction. And when you're talking about, personal injuries, torts, and damage claims, it's all state law. So the whole point of that is saying, if you're, a California resident and you own a Tennessee property, there's no point in putting that Tennessee property in a Wyoming LLC, because you can't go buy another state's more beneficial laws and bring them somewhere else. So the rental property is going to get sued through Tennessee law. And if you plow somebody over in your state of domicile in California, you're going to get sued in California. So don't think you can just say, well, hey, Wyoming, I hear all the stuff about Wyoming LLCs. I'm going to go create this, anonymous Wyoming LLC and ghost lawsuits. The law doesn't work like that. Rule of thumb, put the asset in the state that the asset, LLC in the state that the asset's at. Then you just layer up from there. And for that situation, it would probably be a limited partnership. And the reason we use limited partnerships and not another LLC is there's just so much more you can do with a management company using limited partnerships than you can with another LLC. You can try to be really creative, which you see some people do with operating agreements and saying, okay, hey, we'll use the second layer as a Wyoming management company. I get why they do that, but it's not as good as using a limited partnership, because statutorily you can do so much more that you just can't get away with LLCs without having to subject and submit that operating agreement to a judge. And then it's up to a judge, judicial determination on if I agree with your operating agreement or not. And that's literally just being like, here's my operating agreement on it. Like, please agree with me, please agree with me, please agree with me. And that's just dangerous. Versus saying, here's my limited partnership. Statutorily, these are all the things that are designed by law that you can do with limited partnerships. You just take that right out of the hands of the judge.
So I had a conversation just last week with another attorney buddy, similar to sophistication as you. And he's talking about obviously removing our fingerprints from any type of real estate transaction. It's very similar to what you're talking about. So I guess I'm just curious now, just to trying to, because I'm putting what you're saying in my own mind on some of my own buildings. So does it make the most sense to where, let's just use $1 million example for a second. And I guess I'm gonna get some free attorney advice here as we're on here. But like, let's say it's $1 million building, for example, and we borrow $750,000 from, Community First Bank. We got to bring $250,000 of equity. Would it be beneficial to use a life insurance policy as the equity, who's injecting equity, and then not use that as so much of an LLC, but more as just like a second position lien, where there's just a claimant? Or how would you structure a transaction similar to something like that?
We just keep things simple and tell people, like, closing however you're going to get the best deal, like the best interest rate. A lot of times it's going to be in your name. And then you're going to keep the loan in your name, or however it's going to be closed. All we're doing is transferring title. So then we would transfer title into the proper LLC that it would be in. You're still going to be paying your mortgage or your loan. So whether you're paying it from another business entity or a life insurance policy, like cash value of that, or your own personal name, it really doesn't matter. In the realms of saying like, oh, well, I want the transaction to be, kept off, not have my personal name on it. You're going to get, when you get sued, you're going to be drawn into court anyways, no matter what. You can never ghost a lawsuit. No matter if you have anonymous Wyoming LLCs, or you're investing through a trust, or you're investing through your life insurance policy, it doesn't matter. Somebody has to show up in the court, right? That's you. And then once you show up in the court, the lawsuit's going to be amended and you're going to be named, and then you're going to have to disclose the assets that you own anyways. So the real thing that you want to do when it comes to asset protection is just worry about how collectible are you at the end of the day. And that's where the layers are very important, and having strong charging order protections. And then at the end of the day, if you're above that $1 million net worth mark, having a strong trust where you can get the hell out of U.S. jurisdictional authority and control, and saying like, yeah, valid lawsuit, valid claim, I lost, but guess what? You still can't collect on me because all of my assets and equity are safe in my, offshore account. That's where you want to be. Eventually it might take time to get you there, but once you get to that level, you literally have the strongest protection plan in the world, where you can say, yep, you're right. And then that's a valid lawsuit, but I'm not collectible. That's where you want to be at. You don't want to be hiding assets. You don't want to be trying to play trickery and shenanigans. You don't want to be, we're kind of alluding to like equity stripping and placing like prior liens on top of, the property, so that anyone coming after you will be at a lower level of order to collect on you. Judges hate that type of stuff, and they'll just call it fraud and pierce through it. So the idea is keep the optics very clean and judge friendly, and then just have an asset protection system that's so strong that it doesn't matter if you lose, you're just not collectible.
So would you mind going into talking about just the different types of trusts, LLCs, limited partnerships? I have a partner where we have a limited liability limited partnership, so an LLLP.
Yeah.
Would you mind just kind of giving a 30,000-foot view of what the difference is between these types of, assets are in LLC, again, LLP,
Yeah.
trust? What are those for somebody that has just heard these things for the first time? Can you kind of give us an idea of what those are?
Yeah, so just think like the first layer, okay, the entry layer, asset protection 101, base layer is the LLC, limited liability companies, okay? They hold risky assets like real estate in them. So like anything that has a key or needs insurance or can go boom, they should go into an LLC. How many just depends on what you own and how you own it, okay? The good thing about LLCs, they're cheap and they're easy to maintain. The bad thing about them is they're easily pierced, so their effectiveness is low. That's why they're the base layer entry level protection with insurance. Their veils can be easily pierced, meaning holding the managing members personally liable, and especially for real estate, because real estate, you're just using them as holding companies. Then you have another layer where I'll piggyback it off of this. Like then you have some CPAs that make the error of using S corps to hold assets in like real estate. It's a very bad thing to do. But you hear it a lot from CPAs because CPAs are really only job is to worry about your tax mitigation, right? So it makes sense on why they would recommend, oh, well, hey, tax mitigation purposes, put all this real estate into an S corp and we'll mitigate your taxes better. The problem from a lawsuit perspective of this is that S corps have shares. Shares could be seized and frozen by a judge. Now, when I have to move the assets out in a lawsuit, I can't. One, if it's frozen and seized. The other one is this, if it's not. And I get this call about once a week. Let's say you have 50 million worth of real estate over 20 years you accumulated, all in one S corp. And you're like, dude, Brian, I have way too much risk and liability and equity in one LLC. Like I need to split this stuff up. The problem is most people don't keep enough cash in their bank account to pay all the deferred taxation back to the IRS. Ooh. So when I have to move assets out of the S corp, you have all of that time of deferred depreciation and that you have to pay back. You don't have that kind of money sitting around. And so the assets are stuck. There's nothing I can do with it. So that's why you don't use S corps to hold assets in them. You use them as business entities for tax mitigation purposes, own the assets in an LLC and lease the assets back to the S corp. Just don't stuff assets into an S corp. Otherwise, you're going to lock yourself down and you won't realize it till it's too late. And then you'll call a person like me and there's nothing I can do for you unless you want to owe the, have to pay the IRS a heck of a lot of money back.
Then unless you want to be a very active partner with Uncle Sam.
Yeah. No, exactly. Then you have limited partnerships. So then limited partnerships are kind of, they're the level up from LLCs. So when you go into management companies, a lot of attorneys go wrong of using the next layer up of a management company as another LLC. The problem is that can you do it? Yes, but they're not as strong as limited partnerships because limited partnerships are literally designed to hold multiple assets classes and they have split ownerships designed by statute. So think of it like a split personality. There's the GP side and the LP side by statute. One is the managing member. The other one's what actually owns that LLC. So by statute, we're splitting up ownership from management. Well, you can try to start doing this with LLCs by getting really crazy with operating agreements. But again, you have to submit that to a judge, and a judge will sit there and be like, sorry, son, like we don't do that in this state. You're crazy. You just got this false sense of security. Versus by statute, you can do that with limited partnerships. That's what they're designed for. Then I can add that third layer properly and have your trust own the limited partnership, and then you're just the managing member of the limited partnership. So now we've, by law, statutorily separated out management from ownership. And then you're just the beneficiary of your trust, the managing member of your limited partnership, and you're still just doing one tax filing through the management company. So that's why it's better to use a limited partnership as that second layer versus another LLC.
So, Brian, I'm really just curious to know, like, how did you get into this? Because I don't know a lot of people talking on this type of level in regards to asset protection or this style of management and real estate. That's the game that I'm in too. How does somebody like you get into this? Like, what did you just like turn over a rock and find like an accounting book or an attorney book, or like what happened? I'm curious.
Yeah. So I went coming out of law school, I was working at the prosecutor's office in Santa Barbara, and then the economy tanked in 08, 09, 010. So then I was the youngest prosecutor coming in. So I was the first one let go. And I was like the golden child, I was there for like 4 years interning before I started working there. And then like, yeah, we love you, but we got to let you go. I was like, like, oh, beep. I don't know if I can say that.
Yeah.
But, so I was like, all right, I was expecting to be this high-end prosecutor for a while. And like, who knows where that was going to take me, and then the economy flipped the switch on me. So then I had to go into civil law. And so it was a completely different area of law. So I went into this chop shop firm. I mean, just like, employment law, chop shop. And I think I had 300 open cases all at the same time. Like I didn't see my desk for the first 3 months. It was literally just like, you got to go here to court, deposition here. And I had no one training me on like civil law or employment law. And the owner of the firm was just like, here's these books, figure it out. And so I was just ruthlessly aggressive in all the depositions and court hearings, and started just winning and winning and winning. And I would just like, the law made sense to me. And then I got let go there because it was a family firm, and I was the only one settling cases, and no one else was settling cases, but it's a family firm. And he was like, yeah, the holidays are coming up, and like, I want to have a good holiday. And like, that's my son, that's my son's wife, that's my wife. He was like, so gotta let you go.
Oh my
I was
God.
like, what? And he's like, he's like, yeah, but here it is, man. He's like, you have that magic. And he's like, you're us, like, and after the Carter era. And so just go out and start your own practice. Like you have that, just trust yourself and do it. Moved to Michigan, got into some Supreme Court, cases in Michigan, like, $40 million cases, and just got known as, like a top trial lawyer in the nation. But I got tired of people coming to me after the fact. I was like, hey, I'm getting sued. This is happening. This is happening. I like money. I like investing. I like the tax code. I like trial work. And I'm like, there has to be something better to help everybody out. So I started researching asset protection, but I wanted to do it at a very high level. And there's only 3 people in the nation that do it. And I reached out to all 3 of them. And I just said, hey, this is who I am. This is what I do. I want to become you guys. Let me work with you guys. And I'll do it to where I'll discount myself 20%. You only have to pay me on clients I bring in. But then the caveat is you got to teach me everything that you know. And they're like, kudos to this little kid, like the ball's on you. But sure, we got nothing to lose. And then I just turned the marketing on, and, really dived into everything that they did. And they all taught me everything that they knew. Into these foreign trusts, which we can break down if we got the time. And that's what I work in, is like the offshore hybrid trust for a high net worth clients. But you're just not taught this stuff unless you just happen to stumble into the firms that are doing this at the highest level. You're not taught this in law school. You're not taught this in the bar exam. Attorneys don't know anything about this level of protection. CPAs don't know anything. So when you talk to other attorneys and like they don't understand any of this, it's because we're not taught this. Unless you stumble into that firm that happens to do it, you're just taught what you're taught at the firm you started with. And that's kind of what the legal field, unfortunately, is a copycat system. That's why the legal system It actually took COVID to wake up the legal system just from like how to file documents in court. Until then, you had to show up in the court physically and hand over documents to file in the court. You couldn't even e-file anything until COVID happened.
Well, that's pretty just, I mean, it's kind of amazing how we always like to joke in the real estate world too. It's the same thing as I feel like title companies are the biggest ripoff ever. I mean, it's just like, you don't have to, title companies are essentially almost identical where they're so outdated, similar to what maybe the court systems are. I don't know, but I would like you to go into some of the, like, when you got those high net worth clients, like what do those guys do? I mean, 40 million, 50 million plus, like you've experienced that, you deal with those guys every day. What does that style of ownership, that style of protection, that style of dialogue look like every day?
Yeah, so that is just breaking down the same thing. It's like really no difference than a person coming in with nothing and then someone coming in with 100 million. It's just, what do you own? How do you own it? The difference is once you hit around that 1 million mark, we're using a hybrid trust.
Got it.
Their accounting systems are more dialed in. They understand, they're no matter whether economic good times or bad times, they're always investing because they understand hypothetication of money. Money has to always be moving to make money. Right. So when times go bad, they generally perceive it and they've pulled money off the table to let times go bad and then put the money in to the economy, versus most people hold the money in, let the economy tank, then pull their money out at a loss. So they're just ahead of the curve is all it is. But that's because they've grown, they've gone through it, and they actually, what I will tell your listeners, utilize their advisors. They talk to them all the time. So if you have a CPA, you should be talking to your CPA every month. If you have a good attorney that does like asset protection and you have talk to them, talk to us, tell us what's going on. Like we want to have these conversations. And your CPA, I have so many great CPAs that I'm like, man, I wish my clients would call me all the time, and they never do. And then they just dump this documentation of file stuff on at the end of the year and say, hey, do my taxes for me. And they expect them to be able to be some miracle worker. Like, man, if you just called me throughout the year, we could have saved you so much more money. So it's like, utilize the people in your system. The difference is just that the asset protection trust that we use. And I think people confuse the world of trust because people think one word means everything, right? Ice cream. Ice cream is ice cream, but ice cream's not ice cream. You got chocolate ice cream, vanilla ice cream, strawberry ice cream, Rocky Road. It's all, ice cream based, but there's different flavors and types. Same with the world of trust, right? You got revocable living trust, land trust, asset protection trust. Just because you have a family estate plan, revocable living trust, does not mean it's going to protect your assets. It can't. They're not designed to. There's no teeth to it. They don't have the provisions in them to actually protect you. They're only designed to avoid probate when you die and to avoid, the court system, and then tell who gets what and your medical directives, financial directives. That's all they're designed to. So just because you have that estate plan doesn't mean that your assets are protected. You need to then get an asset protection trust. So then they think of land trust. Well, I got a land trust in real estate. That's like a big topic, big one lately. What they don't realize is a land trust has no protection. It's a privacy mechanism. It's connected to an LLC. So it's only as strong as the LLC, the limited liability company, like limited air quotes, right? Liability company that is connected to, for privacy. So they can't say, hey, I hate Nolan, I'm going to go find out, that he owns this and egg his house. It gives you privacy. Then you have the world of asset protection trust. And asset protection trusts are different types of trust. They're self-settled spendthrift trusts, meaning they're created for you, by you, as your own beneficiary. All right. And I can break this down a little bit more for you here. And all asset protection trusts are irrevocable trusts. So the difference between a revocable living trust is it can be changed, or a judge can say, I don't like this, revoke it and change it, or I will hold you in civil contempt of court. Versus irrevocability means it can't be changed that easily, and a judge can't say, hey, go revoke this, or I'm going to hold you in civil contempt of court. And then they have these really beautiful teeth called spendthrift provisions. And what these are is they're provisions that allow you to protect your assets from creditors. They're the actual teeth behind it. All right. So they're very different types of trust, just like chocolate and vanilla are very different types of ice cream. They're still ice cream, just different types. So when you go in and you say, hey, I want, a trust and an asset protection trust, just realize what's the purpose of what we're creating it for? If it's for tax benefits, maybe look at a charitable trust. If it's for inheritance, maybe go look at a revocable living trust. If you want to protect your assets, we're talking asset protection trust, which then gives us three options. We can go offshore to like the Cook Islands, be a purely foreign offshore trust. You can be domestic, purely domestic in the US, or we can hybrid them together and take the strength of the best of both of them and create them the strongest and most flexible trust based off the pros and cons of both of those. And, you know, I can break those down real quick if you want. Just
Absolutely. Yeah. Break this on, man. This is great.
yeah. So, you know, you got in the role of asset protection right now, we got those three types of trusts, right? Offshore, onshore, and the hybrid. From the historical context of it, the offshore came first in 1984 in the famous Cook Islands when they created the Cook Island Asset Protection Trust. I love the Cook Islands Trust. It's the strongest, it's the best home court advantage. Why it's the best is because they have this beautiful word called statutory non-recognition of any country's, you know, judgments anywhere in the world, including the US. What this means is like if you have a US judgment against you, it's completely worthless in the Cook Islands. They can just throw it in the trash. And then they have these they're statutorily prohibited in even their constitution from recognizing it. So if somebody's going to sue you and you have an offshore component in your trust, they'll have to start their case all over from scratch in the Cook Islands. And then they have to prove their case and meet all these statutory hurdles. And a few of them are the person suing you is going to have to prove their case beyond a reasonable doubt. So the murder standard, the highest legal standard in the world, the 99% sure standard, not the 51, you know, percent preponderance of the evidence. Like, I'm not sure, maybe let's give it to him. I like the color of their shirt.
Sure.
You can't get a contingency fee attorney to represent you there because they're not allowed down there. It's unethical in the Cook Islands, just like it used to be unethical here in the United States. But then we changed that in the 60s. The claim, meaning the lawsuit, it's not amendable, meaning once you file the complaint, that's it. You can't go back and amend it after discovery like you can here in the US. The person suing you, they're going to have to front the entire court cost plus fly in a judge from New Zealand. And if you lose, you pay. And so this is one of the worst things that we don't have here in the United States, you know, like that the loser, you know, needs to pay of the lawsuit. So if you get sued by someone for a completely frivolous, bogus reason, and then you're spending, you know, $200,000 in legal fees to defend yourself, and the judge finally says, hey, guess what? You're right. This is a bunch of BS. Like, I'm throwing this case out. You're still out $200,000 because our legal system is not built around discouraging lawsuits. All right. It's run by trial lawyers. And then there's only a 1-year statute of limitations. So you have literally like what? The strongest trust unarguably in the world, right? The foreign offshore trust. The drawbacks, the negatives of it, they're expensive as heck. You're talking about like $50,000 to start, $10,000 to $12,000 a year to maintain. You have to be out of control of the assets because that's what makes them work so strong. So that's kind of overkill for like 99% of people, but you still like, man, I want that strength, right? And you have all these IRS reporting and disclosures. So what people default to then is going to a domestic trust. Now, the domestic option came 10 years later. Of all places, it started in Alaska. Then, not to be outdone, like Wyoming, Delaware, Nevada are like, hey, we play this game. This is our game, so we want in on this as too. So now about 19 states have some sort of domestic asset protection statute. So they're jumping on board saying like, yeah, our legal system's a threat and we need to do things to protect our assets, but not every state recognizes them. And so the issue here with the domestic side is we have the Constitution. We have the full faith and credit clause. And this means every state must grant the full faith and credit of the judicial proceedings of other states. So what this means is that, for example, Nevada can pass an asset protection statute, right? Which they have that. But it can't ignore a California or a Florida or Washington court order. So where the Cook Islands can just literally throw that judgment in the trash, Nevada can't do it. Nevada has to respect it constitutionally. And now courts and judges, they're just completely ignoring the choice of law clause. And a lot of the case law of all the domestic ones are coming down, just piercing them. You got Bately versus Mortison, In re Hubbard, Hilker versus Steelman. That's a California case with California residents using a Nevada Asset Protection Trust, and the California court saying, sorry, you're not a Nevada resident. We're not recognizing those anymore. We're piercing them. And then that case was upheld by the Court of Appeals. So, you know, and breach means loss of assets. That's just unacceptable. So then the question comes down to like, right, like, okay, Brian, like domestic's expensive as hell with all these IRS disclosures. Like, we're not going that route, but we wish we had that strength. Obviously, domestic's junk. So, but there's no compliance with the IRS and it's cheaper to start, but it's not effective. Like, what do we do? That's where the hybrid option called a bridge trust comes into play. And what that does is taking the strength of both of them. And so you're taking a foreign Cook Island trust and domesticating it through the IRS so that the IRS classifies that foreign trust as a domestic trust by complying with USC section 7701. It's called the court test and control test. So it's like having two passports. You can have your Swiss passport and you can have your US passport. But as long as you have your US passport, the US will always consider you as a US resident. So because of that bridge built through the IRS compliance, we'll stay classified domestically. And what this means is that the trust is cheaper to set up, it's more flexible. You have none of those annoying IRS compliance issues and no really IRS filings whatsoever to disclose with the trust, all because the trust is actually classified as a domestic US grantor's trust. But now you get the power of the offshore in your back pocket if and when you ever need it. So if a doomsday lawsuit came your way, I break compliance by removing you as the trustee, you're still the beneficiary and creator of the trust. It's still your stuff. But now we're no longer in compliance with the IRS from the classification side. Now you are what you are, Cook Islands Trust, with all those statutory hurdles. Lawsuit goes away and gets settled, we re-domesticate it for IRS classification.
Mic drop. Damn, that was awesome. I mean, that's just information that you really can't find anywhere else, man. I mean, it's like, just listen to what you're saying. It's just talking about the highest level of asset protection and education when it comes to do the majority of your clients, is it real estate that they're holding, or is it business equity? Is it like a hybrid of both? Like, what's that kind of
Yeah,
look
it's
like?
both. A lot of them are heavy in real estate, and then they also have, venture capitalist investments or syndications. A lot of them will have high risk jobs like, doctors, surgeons, CPAs, lawyers, business owners. So some of them are also, a lot of them, my favorite ones, like nurses, firefighters, cops, teachers who just self-invested in their own retirement through real estate investment properties over the years and became very successful and built up a multi-million-dollar nest egg. The problem with them is they're going to be retiring. So
Right.
if they lose one of those nest eggs, they ain't going to be rebuilding that back. So they actually need that more than the high-end guys who can take that multi-million-dollar lawsuit, hooked to the lower floating rib, ain't going to knock them out, but it's going to hurt. Versus, the other, cop, firefighter, nurse, that punch is going to knock them out, and then they're not going to be able to rebuild themselves.
No, 100%. And that's it's a great point for even all the listeners, just knowing that at the end of the day, whether you're a $50 million guy or a $50,000 guy, asset protection is it's got to be at the forefront. Would you agree with that? I mean, it's got to be number one.
I agree. And talking to your CPA is number two. Like the order of operation from anyone who's like someone intelligent in this field will say, protect your assets to wherever level you're at. I'm not saying go get Taj Mahal level yet if you're not there yet. But at least get an LLC and insurance. And then as you scale, realize I need the management company. Okay, I hit that $1 million mark. I need now that hybrid trust. Protect your assets properly. Then have your CPAs work their magic through the tax code. But you have to have the combination of the both. But the most important one first is protecting your assets, because if you get sued and lose it, your magical CPA has nothing for them to do their job with.
You're really in a tight spot when it comes to 100%. All right. Well, Brian, look, here's where we're at, man. I appreciate all your time. As we get out of here, do you have any, how can our listeners like reach out to you, man? Like, obviously I'll put your information in the bio of this website or of our episode here, but most importantly, I mean, how can people get in touch with you, follow you? Obviously, like I said in the introduction, you've been on multiple, the Bigger Pockets podcast, other podcasts, some major league outlets, social media wise. What can people do to get in contact with you in regards to doing business with you?
Yeah, jump on my website, www.btblegal.com. I use it as an educational resource for you. Lots of case law, lots of educational videos, a great frequently asked questions section. Educate yourself. If you're like, hey, I want to go, start looking into asset protection, The more knowledge you have, the better questions you can ask the attorney and CPAs you're talking to where if they don't have answers for you, hang up the phone and go talk to somebody else.
Right.
And just get yourself up to a par. Okay. So you know if you're being BS'd or not. And then another, good resource is email me, Brian, BRIAN at btblegal.com. I generally will give you like a 30-minute free consultation, whether we're the right fit or you're the right client profile for me or not. Like, I'd rather just have you have a good breakdown and then you can do what you want from there versus just, filtering through a bunch of BS or salesman promoter crap that you're getting.
I mean, that's, as anybody gets on the internet today, it's whatever you type in, you're going to have half the internet love it, half the internet hate it. So, but guys, I mean, this is $10,000 of attorney legal fees right here. So Brian, I'm sure you'll be sending me an invoice for this after we get off of here, or maybe we'll do some deals together. Right. I mean, come on,
man. I like making money.
Hell yeah. Well, look, hey, Brian, again, man, I appreciate your time today, man. It was honestly, I'm excited about this and just seeing where things will shake out. But, I'll put all your information in the link of this episode, man. We'll kind of chop it up and go over there again, man. Thanks so much for your time.
Thanks.
Cool. Thanks, Brian.